Morning, everyone. Welcome to our first of 3 immigration webinars to prepare you for the end of free movement. For those who do not know me, my name is Rachel Harvey and I'm a legal director here at Shoosmith. I'm joined today by my colleague Jo Tunnicliffe, who is an associate in our employment team in our Birmingham office, and she specialises in employment and corporate immigration. So this webinar was scheduled to end at 11 today, but as today is Armistice Day, we will end at 10:55 to allow those who wish to observe their 2-minute silence at 11. So we'll end at 10:55. If you've got any further questions that haven't been, looked at over the presentation, the team will be in touch, and you will have our contact details so you can send them further. So obviously we'll be being given joining instructions in terms of the stuff that Steph has already shared with you. So we will get started in terms of the topics that we're covering today. So in preparation for the end of the transition period on the 31st of December, we wanted to do this webinar basically to assist you with communicating with your current EU employees who are already in the UK. We wanted to give you some pointers in terms of preparing for the end of free movement. And also, we wanted to give you some information about the new routes that will be introduced on the 1st of January 2021. We've received a number of questions in advance of the session. And like I said, hopefully they will all be addressed. But if there are any outstanding, you will have the opportunity after the session to ask those questions. So I'm going to hand over to Jo, who will let you know a little bit about how the EU settlement scheme works in practice.
Morning, everyone. So in terms of the EU settlement scheme and how it operates at the minute, currently all EU nationals resident in the UK prior to the 31st of December this year will be required to apply for the EU settlement scheme before the 30th of June 2021. The following slides will cover how the EU settlement scheme works in practice, and essentially the individual applies using their current passport and their Android or recent iPhone or tablet. The UKVI contact HMRC to verify when the individual obtained their national insurance number. And within about 30 to 45 seconds, they confirm in principle whether that individual is eligible for settled or pre-settled status. It's important to note that should an individual have been in the UK for longer than 5 years, but their national insurance record does not confirm this, the individual must not accept pre-settled status. Instead, they will have the opportunity to scan further evidence to confirm they have resided in the UK for the 5-year period that they wish to rely on. So this slide sets out a summary of the 2 statuses and the difference between them. Already over 4 million EU nationals have applied for one of these 2 statuses. I'd say probably one of the most important things to take away from this slide is the requirement that when applying, individuals must disclose criminal offences. It can be the case that failure to declare the criminal offence can sometimes be worse than the actual conviction itself. The decision that will be made based on the criminality are made on a case-by-case basis. There isn't a hard and fast rule, but the type of the offence and or the quantity of the convictions will be taken into account. And recently the government have tightened up the criminality assessment to bring them in line with the rest of the world in terms of those who have had prison sentences for 12 months or more. And the assessment is conducted on a case-by-case basis, like I said, and is based on the applicant's personal conduct and circumstances in the UK as well as overseas, including whether they have been including whether they have any relevant prior criminal convictions as well, and whether they have been open and honest in the process of making the application. Applicants are required to provide information on previous criminal convictions in the UK and overseas, as I've said, and are only required to declare past criminal convictions that appear in their criminal record in accordance with the law of the state or of conviction at the time of the application. However, there is no requirement to declare spent offences, cautions or alternatives to prosecution, for example, fixed penalty notices for speeding and things like that. So once approved, the individual will get an explanation letter from the UKVI, which sets out responsibilities and details of absences. The digital profile will look something like the slide that we have on the screen. And after December 2020 or June 2021, whenever the application is confirmed, when an EU national needs to prove their right to work, they will have to do so by sharing a code with you as their employer. Employers will then have to use an employer-facing service along with that code and the individual's date of birth to assess whether they have the right to reside and as such the right to work in the UK. It will then bring up the individual's profile with the employer, which as the employer you must retain for your records as well.
Thanks for that, Jo. So currently, the UK government are not stating that retrospective right to work checks need to take place. We anticipate that this could change, and the government will task our clients to act as border officials to ensure that EU nationals have applied by the deadline of the 30th of June 2021. So we'll discuss a little bit about how you can prepare for this. At the minute, if you've already checked an EU national's passport or ID card up until the 31st of December 2020, that will give you a continuous statutory excuse. Obviously, if this changes, we will let you know, and we'll let you know how to go about carrying out retrospective right to work checks. I think the most important thing is to carry out an audit of your workforce. In the event that they bring this in quite quickly, you will need to ensure that you know who will be affected by this. So if you audit your workforce now, you will at least know who you need to ask for this status going forward. I think one of the common themes that came out of the questions in advance was, how do we communicate with our workforce now and in the future? And that's a really important point. At the minute, the Home Office and the government have been really clear in that you cannot ask for someone to provide you evidence of their settled status at this stage. You can't force them to make their application. So the rhetoric that we've been advising is really positive communications with our employees. So asking them if they need any support, letting them know what could happen if they, for example, don't make an application, and really positive messages around how easy it is to make the application, as Jo's just demonstrated, and that they should do it sooner rather than later to prevent any issues. We're not sure about the position at the minute of those who have entered before the 31st of December but haven't already applied by the 30th of June, and what documents you're able to accept. This question has been with the Home Office, so we're hoping we'll get a decision pretty soon on that. So, like I said, the position of EU nationals in the UK and residing here before the 31st of December 2020 remains unchanged. They continue to have the right to work and live here. Problems could arise if they've not done their application before the deadline of June 2021 and they travel. So, for example, someone may travel and they've not made their application either because they didn't want to or they didn't know they had to. They could potentially be stopped at border and not be able to enter the UK. There are other issues that we've had already. Some of our border officials don't know that it's a digital status. There's no stamp in their passports. So it's something to think about, especially because people may be travelling around December for Christmas, COVID depending, and the New Year. So it's really important that as many people have applied for it and can evidence it as possible. So advising your workforce to travel with the email that they've received, potentially a letter from employers or their employment contract, wage slips, just to show when they come back through, yes, I've applied, and if I haven't applied, I've already been living in the UK before the 31st of December. A good toolkit is on the government website that will give you some posters, flyers, and advice on how to communicate with your workforce The posters are available in 25 different languages as well, which is really useful, although this was only, they only issued that probably about 6 months ago. It's really important that it is communicated to them. Deadline to apply is the 30th of June 2021, but our communication has always been sooner rather than later is better. And so again, whilst you're not able to request formally the evidence of EU settled status at this stage, if people want to volunteer that evidence so that you can tick those people off your list of those you might have to retrospectively check, it would be a good thing to do. People may offer it up, they may not, but some people may not even know that they have to do it. Again, so just preparing for the end of free movement as we've known it. Again, auditing of your workforce is really key, so that you're fully aware of the amount of EU nationals who are currently working within the business. Applying for a sponsor license, and we'll touch on this with the new rules later. If you don't currently have a license and you think you might need one based on the next few slides, you should apply. If you do have one, you need to make sure that you have access to it. You'll be surprised at how many of our clients have no access to their license because someone who set it up has left, and obtaining access is quite difficult if you have no other users on there. Also, just thinking about if you regularly move individuals from your overseas branches in the EU or elsewhere, are you sure that those branches are linked to your current license? So when you set up your intra-company transfer license, at the time, it was probably unnecessary to add your EU branches. It's now necessary to do that. And it's fairly straightforward, but at the minute, there's a possible lead time of 18 weeks to do that. So again, sooner rather than later is the message. So now we'll turn to the new routes, so the new immigration rules as of the 1st of January. So essentially this brings all EU and non-EU nationals into the same boat. This is for Tier 2 General, and I'll touch on Tier 2 ICT later. So there are certain mandatory criteria, so after the criminality checks. So there must be a job offer from a licensed sponsor. The major change here is the job offer must be at a minimum skill level of A level or above. Currently, this is graduate level. So it's a reduction in the skills level. They also must meet, the individual must speak English to an acceptable standard, which is B1 of the CEFR. And they will have to evidence that by having completed a test or having a degree taught in English, which is comparable to a UK bachelor's degree. Meeting the mandatory criteria will get the applicant 50 points, and then they must obtain a further 20 points through a combination of points for salary or a shortage occupation job or having had a relevant PhD. So normally, if the applicant is paid the higher of the general salary threshold of 25,600 or the rate for the job that the Home Office set out in Appendix J, they will get an extra 20 points. And obviously there is scope to get extra tradable points if the applicant is paid less than that. So for example, if the Migration Advisory Committee have recommended that job is now on the shortage occupation, or it requires a PhD qualification. There are also different minimum salary rules for workers in certain healthcare and education jobs. And for those that the Home Office will class as new entrants who are at the start of their career. And the new entrants are normally 30% lower than the rate for experienced workers. However, the minimum of 20,480 must always be met. So another big change is that there is no cap. At the minute, there is around 21,000 new entrants to the UK that can come via Tier 2. And you have to advertise the job out to the resident labour market test first. That again will go. No resident labour market test, no cap. So essentially, they're widening the shortage occupation list as well. So Migration Advisory Committee just recommended last week or the week before to the Home Office that certain additional jobs should be added, which may mean that you would not normally be able to recruit a bricklayer. You will be able to do that under the proposed rules. It hasn't been finalised yet, but we expect certain jobs to be added to that list. So it's actually expanding the use of the Tier 2 going forward for EU nationals and indeed non-EU nationals. The final point on that slide is about the immigration skills charge. Basically, the immigration skills charge is paid to the government when you sponsor someone. So you can sponsor someone for 5 years, and if you're classed as a large sponsor, you will pay the government £1,000 a year. If you're classed as a small sponsor, you will pay much less. And then, and that is the Home Office essentially brought that in to ensure that you as employers recruited from the UK before that. So you just need to bear that in mind in terms of going forward. We have heard for the last 3 years that they might increase that, but at the minute, nothing more has been said. So just to quickly touch on the other routes, which will be less common. So this won't come in January 2021, the highly skilled workers. It's a broader unsponsored route for people to come into the UK, and they're obviously exploring proposals for the additional routes at the minute. This route will be capped. There won't be a job offer, but it will be people with certain skills that will be allowed to come into the UK. So graduates, again, bringing back the post-study work route, not launched in January, but launched in the summer. So the opportunity for those people who have been in the UK and have completed their degree or PhD or masters at certain universities to extend their visa for 2 years. And then at that point, they will be able to switch into the Tier 2 general category if you wish, for example, to retain them. So the initial 2 years is an unsponsored route. You don't have to sponsor them at all. They just have to show that they've completed their degree and they have this graduate visa. They don't need to do English language because they will have already demonstrated that at the beginning. Intracompany transfers. The biggest difference between this, the new rules for Tier 2 general and intracompany transfers is that there is no reduction in skills level. So if you are bringing someone over from your EU entity or your Australian entity or wherever it may be, there is no reduction in skills level. This will still be a graduate level role. It doesn't lead to settlement. Again, one of the questions that we had was, why would we ever sponsor under ICT if we can go general? One of the things is that you can move people for short term. There will be no cooling off period from the 1st of January, and there is no English language, but there is a minimum salary and there is a minimum length of service. But despite that, even if you come on your intracompany transfer, you can have the opportunity to switch to the skilled worker route, which will ultimately lead to settlement after 5 years. So again, just to recap, in terms of your ICT license, if you have one, make sure that it's got all of your entities worldwide on going forward to make sure that you can transfer EU nationals at short notice. And so finally, the frontier worker route. So you're a frontier worker if you're an EU citizen and you're employed or self-employed in the UK but live elsewhere. So discussions are ongoing. So this is another question about what is the UK worker who works in the EU classified as a frontier worker. discussions are ongoing regarding reciprocal arrangements, which is why it's not coming in on the 1st of January, because we're having conversations with the rest of the world, of the rest of Europe, should I say, about what kind of reciprocal arrangements we'll have. But later, well, in 2021, the government will launch a Frontier Worker Permit scheme. So individuals will be able to apply without you sponsoring them if we can prove they have frontier worker statuses. Applications are free, and they can apply online from inside or outside the UK. So from the 1st of July, individuals will need to hold this Frontier Worker Permit. So it's not yet open, but people have to have it by the 1st of July 2021. They're saying until 2021, individuals can continue entering the UK as a frontier worker using their passport or ID card, and then they must apply to the Frontier Worker Permit as soon as the scheme launches. And to end, essentially, just to wrap up the other changes that will come into play on the 1st of January, as part of a phased programme, the Home Office will introduce a universal permission to travel requirement, which will require everyone to travel except British and Irish nationals and those who need formal visas to seek permission to travel in advance. So it's similar to the ESTA that we do when we go to America. So they're introducing electronic travel authorizations for visitors and passengers travelling throughout to the UK. And it's a very light touch approach, or so they're saying at the minute. They will conduct security checks, and so they can be more informed about decisions to allow people to enter. Most important thing on this slide, I think, is normally EU nationals can enter the UK using their ID card. Unless they've got EU settled or pre-settled status from January 2021, they must use their passport to enter the UK. So again, that's something to think about for people travelling as visitors to your businesses or maybe for work. Then they will need to make sure that they travel on their passport. Obviously, there are other negotiations still going on, and hopefully, as soon as we're doing obviously a series of 3 webinars. So our last webinar is mid-December when we discuss right to work checks. But I think then we'll have a clearer picture of what will happen from the 1st of January. So we're kind of almost bang on time. I have seen a couple of questions come through, which we'll be able to respond to. And then, as I said, the team will send out the recording and our details so you can send any further questions. So I hope that was useful for everyone. And yeah, see you soon. Thank you.